Music Copyright Laws with Ricky Berger, Esquire, from the Audio Skills Podcast. Welcome. First and foremost, I am a musician, singer, songwriter, producer, and arranger, and future owner of a successful streaming service. In this presentation, I will be reviewing and summarizing information about copyright issues. I will be using a new iTunes podcast called the Audio Skills Podcast. I listened to episode 2. The host is Scott Hawksworth, founder of RecordingExcellence.com and the Audio Skills Podcast. Lawyer Dr. Ricky Berger is a guitar player and has been a lawyer for over 30 years. He has been an adjunct professor at the University of Massachusetts at Lowell for almost 8 years, teaching publishing and copyright law. 3 key concepts. Number 1, song protection and rights. There are 2 distinct rights associated with a song, and these are the questions that must be answered. Who owns the rights to the underlying physical work? Who owns the rights to the sound recording? There's a difference between the song and the sound recording. Inside the sound recording is the song, but inside of the song are the words written by a person or persons. Before the song is recorded, it is considered to be a musical work that exists, and the ownership must be established. If the copyright includes more than one person, the next questions are, who is in charge of the publishing, administration deals, or auditing? There needs to be an agreement between all parties involved with the song and the legalities finalized prior to recording so that disputes can't arise. Remember this, the filing of a statement of ownership in the Copyright Office is a statement. It is not necessarily the truth. Berger. Putting for demonstration purposes only on demos helps maintain the right to first use so no one can do covers. However, if you put music on YouTube or a similar site, it is considered to be publicly distributed and covers can be made. Number 2, sampling and remixing. If a song has a substantial similarity to or is written from the vibe of an established song, don't record it without getting permission. This is a fair use liability, and these cases are always decided in court, and the outcomes are unsure. When remixing, it is better to do a deal and get licensing terms and permissions before playing around with song stems. Because the stems could be considered to be pirated, remixes are considered to be a derivative work, and only the copyright holder holds the right to copy. Number 3, recording covers and distribution. In order to legally do covers, the copyright holder does not need to be contacted, but a compulsory license must be gotten from a clearinghouse, such as the Harry Fox Agency. The purpose for usage of the song must be included on the paperwork. If using the cover song for download, the form must show how many people are expected to download the song. Then, multiplied times the royalty rate, is what I would pay for the license. If more people download the song, another license must be gotten. For streaming, it is the same, but it adds royalties. When a song is publicly performed, the owner gets royalties. Key point to remember, YouTube covers cannot be combined with moving images. The liability for this infraction is damages up to $250,000. This podcast was geared towards independent producers and provided insight into the copyright and the liabilities associated with it. Attorney Berger quoted the sections of copyright law that we should be most familiar with and explained the liabilities associated with them. In the future, these concepts will help me and the artists I produce or manage avoid legal liabilities, stay out of court, and maintain good business practices.